Namaskar. In a case where a land or building or both are transferred for a consideration less than the stamp duty value, the value which is adopted, assessed, or assessable by the state government authorities for the purpose of payment of stamp duty is considered as full value of consideration for computing capital gain. A question arises whether, in case of transfer of land or building by way of compulsory acquisition under the Land Acquisition Act or relevant statute, whether the provision of Section 50C shall be applicable. This issue came for consideration before the Honorable Calcutta High Court in the case of Principal CIT versus Durgapur Projects Ltd, reported in 454 ITR 367. Honorable High Court, taking into consideration the object behind insertion of Section 50C in the Income Tax Act, held that the provision has been designed to control the transactions where the correct market value is not mentioned and there is a suppression of the correct value by the parties to the transaction. As in the instant case, it is an acquisition of the land by the government by way of compulsory acquisition. The appellant department, the income tax department, cannot be heard to say that there was a suppression of the value, and consequently the question of invoking Section 50C of the Act does not arise. Further held, by interpreting the expression for the purpose of payment of stamp duty in respect of such transfer used in Section 50C of the Income Tax Act, applying the principles of interpretation as emerges from the decision of the Honorable Supreme Court discussed in the order, the Honorable High Court held that the term transfer used in Section 50C has to be given a restricted meaning, and the same do not have a wider connotation so as to include all kind of transfer as contemplated under Section 247 of the Act. The court accordingly held that the provisions of Section 50C shall be applicable in cases where transfer of the capital asset has to be effected only upon the payment of stamp duty. In case of compulsory acquisition, the transfer of the property takes place by operation of law, and the provision of the Transfer of Property Act or the Indian Registration Act do not have any manner of application to such transfer. The question of payment of stamp duty also does not arise in such cases. The Honorable High Court accordingly held that in case of compulsory acquisition of a capital asset being land or building or both, the provision of Section 50C cannot be applied as the question of payment of stamp duty for effective such transfer does not arise. The Honorable High Court further held that in the instant case, the property was acquired under the provision of the National Highway Act 1956. The property vested by operation of the said statute, and there is no requirement for payment of stamp duty in such vesting of property. As such, there was no necessity for an assessment of valuation of the property by the stamp valuation authorities in the case in hand. Accordingly, Honorable High Court held that the provision of Section 50C are not applicable in a case where the land is acquired by the government under the Land Acquisition Act. Thank you.